Welcome back to FDVN's channel. In today's video, we will introduce a new vocabulary lesson on the topic of criminal procedures. Discretion exercised by prosecutors in both the screening and selection is great, but not absolute. It is constrained by the Constitution. Accordingly, prosecutorial discretion is subject to limited judicial review in cases in which selective prosecution or vindictive prosecution is alleged. Selective prosecution is a violation of the Constitution's guarantee of equal protection of the law. To establish selective prosecution, a defendant bears a heavy burden to show that others similarly situated were not prosecuted and that the defendant's prosecution was deliberately based upon an unjustifiable standard such as race, religion, or other arbitrary classification. Bordenkircher versus Hayes, 434 U.S. 357, 364, 1978. Vindictive prosecution violates due process. Vindictive prosecution occurs when a prosecutor increases the number or severity of charges to penalize a defendant who exercises constitutional or statutory rights. In Blackledge versus Perry, 417 U.S. 21, 1974, a case involving a felony charge brought against a defendant who exercised a statutory right to appeal from a misdemeanor conviction. Preliminary hearing. The initial appearance before the magistrate may or may not include a preliminary hearing. At the preliminary hearing, also called the preliminary examination, the magistrate must determine whether there is probable cause to believe that a felony was committed and that the defendant committed it. The purpose of the preliminary hearing is to provide another judicial determination of probable cause and to protect the defendant from a totally baseless felony prosecution. Rule 5 of the Federal Rules of Criminal Procedure provides that, when the preliminary hearing is required, the magistrate judge must hold the preliminary hearing within a reasonable time, but no later than 10 days after the initial appearance if the defendant is in custody and no later than 20 days if not in custody. A preliminary hearing is not required if the defendant is charged with a petty offense or misdemeanor or if the defendant waives the hearing. Moreover, a defendant is not entitled to a preliminary hearing if the defendant has been indicted by a grand jury since that body has already established probable cause exists for the defendant to stand felony trial. The preliminary hearing is a formal adversarial proceeding conducted in open court with a transcript made of the proceedings. The U.S. Supreme Court held that the preliminary hearing is a critical stage of a criminal prosecution, entitling the defendant to have an attorney present at the hearing. Coleman versus Alabama, 399 U.S. 1, 1970.